Welcome to Leaflet Videos. We are going to be discussing today the legalities of the disqualification of Rahul Gandhi as an MP, which has happened just a few minutes ago, but of course with effect from 23rd March 2023. We have with us a very distinguished constitutional lawyer, Mr. Mohan Katarki. Welcome, Mr. Katarki, to this brief discussion.
My pleasure.
Thank you. Uh, Now, Mr. Katarki, please tell us, what do you think of the legality of this disqualification? After all, there's a stay of sentence, as we all know. In the context of the stay of sentence, what is your legal appreciation of the manner in which the disqualification has been rendered in less than 24 hours?
Yeah, the first thing is there is a legal provision which says that if a member of parliament is convicted for 2 years, he stands disqualified from the membership of the parliament. Now the question is, what happens if the court which has convicted him has stayed the sentence but has not stayed the conviction? In my view, stay of sentence is not a bar for disqualification. Disqualification will follow until the court of competent jurisdiction, that the High Court of Supreme Court, grants a stay on the conviction. There is also debate for a long time, beginning from the Rama Naran case in 1988, whether the court can stay the conviction. Usually, the courts grant a stay with regard to the sentence or with regard to the implementation of the order or direction, whatever. But conviction stay means the finding of guilt arrived at by the court. If it is stayed, that means by interim order, you are declaring something what the court found as not valid. So there has been some discussion, but I think it was more of a semantic. The courts have finally taken a view that conviction can be stayed in an appropriate court case if the court finds there are grounds for such a stay.
Yes. So I would like to draw your attention to the judgment delivered by a bench led by Justice Diva Chandrachud, in which he has taken the view that convictions can be stayed. Now, if a conviction can be stayed, then my question is, at the end of the day, the statute, the Representation of People's Act did have a provision which says that the effect of the conviction will not operate for a period of 3 months. However, this was struck down by a judgment of the Supreme Court in Lily Thomas, but purely on the ground that the legislature had no authority to usurp a judicial function. They actually also suggested that a legal remedy would be available with the courts to stay the effect of the disqualification. Now, tell me whether, in your opinion, a reasonable amount of time should be given to a person who's convicted, especially when the sentence is stayed, to approach a competent court of law for an appropriate remedy. And would you agree that in this case, that reasonable amount of time has not been given?
Yeah, I generally agree that there should be a provision of law which gives a time for a member of parliament who has been convicted to approach the higher court seeking a stay of the conviction. But that's what actually the parliament had done by amendment of section 8(3), which the Supreme Court thought that it is unconstitutional in its view. I'm not agreeing with the judgment, but the Supreme Court thought that it is unconstitutional because once there is a judicial verdict of conviction, that can be stayed only by a higher judiciary, not by a parliament, by legislation. I'm not sure whether it is a correct approach the court took, but that is the approach the court has taken. In view of the approach taken by the court, it is not possible to make any further legislation, bringing the same back in a different manner. The only remedy now is under the constitutional system, as the Supreme Court has interpreted the law, that we have to apply to the Supreme Court or the High Court, being the higher courts, and seek a stay of the conviction rendered by the magistrate.
Yes, we are, however, stuck with a situation where we've gone beyond the conviction and there has been an order of the speaker notification, which says that he stands disqualified. Under the circumstances, if he were to approach the court today, would the court be in a position to restore status quo ante, namely say that the order of the speaker will not operate because we are granting a stay of the conviction?
Well, there has been some, again, a legal view that once a disqualification has taken place by force of law, and subsequently whether the court can grant a stay which relates back to the date and revive the membership of a disqualified member. I don't think there is any legal hindrance. It can certainly revive if the court grants a stay. Certainly, it relates back to the date on which he was disqualified. So, to that extent, the speaker order stands stayed or kept in abeyance, whatever you say, till the court renders the final judgment. That's how it is.
If you were to advise Rahul Gandhi, what would you advise him to do today?
Well, I still advise him that he should clarify his statement, which he alleged to have made, that why all these thieves are Modi. He must say that I did not intend to really say that all Modis are thieves. All that I intended is that some of the Modis who are suspected in a bank fraud are thieves. Therefore, my statement no way hurt the reputation of any of the other Modis who are held in high esteem by the public. And with that clarification, I think the matter should find its end, even in the appellate court.
Are you
If you have not clarified already.
Are you suggesting that he was referring to Nirav Modi and to Lalit Modi?
Maybe, whatever it is, he must clarify that whom did he refer. Or it was just a joke type. I don't think it was a joke. He did refer. And you must clarify that, well, it was referred to be some persons who are suspected to be involved in the bank fraud case.
You seem to be suggesting that there was no case for defamation at all.
Well, I don't think there was any case for defamation because there are two ways of looking at it. Well, firstly, he said, I don't know why all thieves are Modi. Okay, this is different from saying why all Modis are thieves. If you had said why all Modis are thieves, then certainly a person having a surname called Modi can come and make a grievance. Because explanation 4 to the section 499, which is a departure from the common law, permits a class of people, a person belonging to a class, to lodge a complaint, or grievance can be actionable, right? So to that extent, it is possible. But here the thing is, he has not really said that. What he has said is why all thieves are Modi. I don't think there is any way one can hold that it is a violation of section 499. But that is for the High Court to look.
What would you say about the fact that he already has said that in the light of the conviction, he will not enter parliament?
Well, it's a political decision for Rahul Gandhi. Many, in fact, said that he should have gone to jail yesterday itself straightway and made a big show. I will not ask for a bail. Some people say that he should not even bother to ask for a stay of disqualification. If a magistrate sitting in Gujarat, writing a judgment in Gujarat, 174 page, can disqualify a member of parliament elected by lakhs of people in Kerala, it's something wrong with the constitution and the legal system. And he must make a point out of this kind of a system which exists in India. Well, that is a viewpoint. But it should, I think, ask for a stay because ultimately we will have to see that he remains a representative of the people of Kerala who have elected him. We cannot deny them representation in the parliament.
One last question.
Sure,
I would like to draw your attention to Article 103 of the Constitution of India, which appears to require a declaration of this kind to come from the president. It says when the question arises as to whether a person is disqualified, the matter will be decided by the president after consultation with the Election Commission. Do you have anything to say about this article?
I'm not sure this article will apply to the disqualification which operate by force of law under section 8, because that is made pursuant to Article 101 of the Constitution, which provides for disqualification and empowers the Parliament sui generis to make a law, and that has been made, and that is very clear. Thereafter, I don't think President can have any say by reference to Article 103 of the Constitution. But this matter requires examination, because if there is a power in the president and he is going to take a call, and well, then we'll have to say in what kind of cases this applies and in what kind of cases it doesn't apply. That needs to be looked into.
We can anticipate, though, that the Election Commission will issue a press note calling for a by-election in the seat. Now, what were to happen if an election were to go through and in an appeal, Mr. Gandhi's appeal is allowed, it is held, there is no defamation and therefore no disqualification? Would we then end up in a situation in which we have two MPs?
Yeah, in that case, the second election will be subject to the outcome of the appellate court's order. If in the appeal Gandhi succeeds, naturally the election held by the election commission on a assumption that the vacancy has arisen will be declared null and void.
Thank you, Mr. Katarki, but it appears to me that part of the problem lies with the fact that the Supreme Court of India, when it decides cases like Thomas, leaves a lot of silences. Laws are declared unconstitutional without understanding the implications of the unconstitutionality. And would you agree that this is one such case?
Well, it is part of the general theory that laws made by the parliament and the declarations which the court grants are very general, and there is always a gap between the facts of individual case or individual situations and the general propositions which the law lays down in any provision. And that's why we see a lot of litigations between the law and the actual situation. And this is something which is not peculiar to our constitution or our situation. It's always exists, right from the time Aristotle and Plato debated on this. Should there be a law at all with a general proposition?
Thank you, Ms. Katarki, but I would like to wind up this conversation by saying that when the Supreme Court creates a problem through one of its judgments, it has a duty to give the solution. And if it is said that Parliament has no power to decide whether a period of 3 months should be given, enabling the MP to file an appeal, then that reasonable period should be given by an order of the court to enable a person to appeal before a disqualification can be announced by the Speaker.
Yeah, I see quite well a point what you say, that if the court has struck down section 8, which had provided some breather time, the court must then lay down a guideline how a magistrate or the court below should proceed whenever they convict a member of parliament, because this is consequences are serious, that people are being deprived of their representation in the parliament. And I agree that every judge must be given a guideline that when he convicts a person, at that time, he should take into account and not only stay the sentence, and he should also stay the conviction of the guilt of the person. So that gives a protection that there will not be any immediate disqualification.
Thank you. On that happy note, we conclude our discussion with our constitutional in-house expert, Mr. Mohan Katarki, who is also on our editorial board of the leaflet. Thank you, Mr. Katarki, for these
Thank you.
few precious moments.
Charming lady. Thank you.